Ready, start. It is also averred in the impugned FIR that the respondent number 4 was also directly involved in the above case. From the allegations taken in the FIR at its face value, it can be seen that the case of the appellant complainant is that even much before her husband died, he used to be blackmailed by respondent numbers 2 and 3. According to her, a week before her husband's death, her husband had been receiving continuous calls from the above persons, and whenever he received such calls, he was completely upset and had decided to commit suicide. If the version of the appellant complainant is to be accepted, the question remains as to why she kept silent from 14th April 2024 till 22nd May 2024. If her husband was upset a week before his death, whenever he received calls from respondent numbers 2 and 3, and if he was blackmailed by the said respondents, then nothing could prevent the appellant complainant from reporting this matter to the police immediately after the deceased committed suicide. Thus, it is apparent from the material on record that all these allegations were an afterthought. In the case at hand, taking the allegations in the FIR at face value, the incident at the Mahalok Adalat had occurred on 17th February 2015, while the deceased had committed suicide on 20th March 2015. There is a clear gap of over a month between the incident at the Mahalok Adalat and the commission of suicide. We therefore find that the courts below have erroneously accepted the prosecution story that the act of suicide by the deceased was a direct result of the words uttered by the appellants at the Mahalok Adalat. The cardinal principle of the subject matter at hand is that there must be a close proximity between the positive act of instigation by the accused person and the commission of suicide by the victim. The close proximity should be such as to create a clear nexus between the act of instigation and the act of suicide, as was held in the case of Sanju alias Sanjay Singh Sengar within bracket supra bracket close. If the deceased had taken the words of the appellants seriously, a time gap between the two incidents would have given enough time to the deceased to think over and reflect on the matter. As such, a gap of over a month would be sufficient time to dissolve the nexus or the proximate link between the two acts. A perusal of the judgment of the High Court itself would reveal that the government pleader appearing in the case has submitted before the High Court that the entire investigation was complete and what was remaining was the filing of a final report before the concerned court. The learned single judge has observed that he has perused the entire investigation papers, and perusal of the same revealed that there is not a titter of a document that would pin respondent numbers 2 to 4 down for any act of abatement for suicide of the husband of the appellant complainant.